Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wa salatu wassalamu ala Rasulullah. Members of the press, this is actually a press statement by the Muslim leaders on the Supreme Court, on the recent Supreme Court ruling on inheritance rights for children born out of wedlock, issued today, of course, here. Let me begin by reading the statement. In the name of God, the most merciful, the most gracious, we, the Muslim leaders in Kenya, representing religious institutions, community organizations, legal scholars, and faithful at large, issue this urgent and firm statement to express our strong condemnation on the recent Supreme Court ruling on the right of children born out of wedlock to inherit property from their fathers. This ruling, while made under the guise of quality and justice, is a direct affront to the Islamic faith, which is not only practiced by millions of Kenyans, but is fully protected under the Constitution of Kenya 2010, especially under provisions on freedom of religion and the application of personal law as stipulated in the Constitution. The Constitution, through the Qadhi's courts, allows Muslims to be governed by the Sharia Islamic law in all personal matters, including marriage, divorce, and inheritance. Our faith holds that lineage, family bonds, and inheritance rights are sacred and governed by clear, defined injunctions. Any attempt to impose a blanket civil or Western interpretations of family law drawn from Christian Judeo principles, this needs to be understood that according to Islamic Sharia, children born out of wedlock can inherit from their mother and vice versa. They can only be granted a gift, hiba, during the father's lifetime or be included in the will, wasiya, where they can be bequeathed up to 1/3 of the estate. This judgment, therefore, undermines the sanctity of what Muslims hold dearly to be defined law, which stipulates clear guidelines on inheritance, which does not recognize inheritance rights for children born outside of a legitimate marriage. It violates the constitutional right of Muslims to be governed by their religion in matters of personal law, as outlined under Article 24 and Article 32 of the Constitution. It also sets a dangerous precedent that will cause confusion, disharmony, and social havoc in the Muslim community. It clearly undermines the sanctity of marriage, which is the foundation institution of family life in Islam and other faiths. It is an affront to the law of succession, Cap 160, which exempts Muslims from the application of the Act, and where it states in Section 2, Subarticle 3, that the provisions shall not apply to the testimony or to the testamentary or intestate succession to the estate of any person who at the time of death is a Muslim, to the extent that the devolution of the estate is governed by the Muslim law. We are alarmed that the apex court, which is meant to protect and interpret the Constitution with fidelity and sensitivity to all its provisions, has chosen to ignore clear legal and constitutional provisions and conveniently choose to override religious protections and values in favor of a single worldview that fails to account for Kenya's religious and cultural diversity. This is not the first time that the Supreme Court has made such stateful decisions, which is a clear affront of Islamic faith. A similar judgment was made in January 2019 when it overturned a Court of Appeal ruling that had affirmed the constitutional provision for freedom of worship for Muslim female students to wear hijab in schools. More than 6 years down the line, the apex court has deliberately failed to hear the application for a review of the judgment of the hijab case. In the light of this, we hereby, 1, reject and condemn in the strongest terms possible this ruling as an offensive, unconstitutional, and deeply harmful to our religious beliefs and social fabric. 2, call upon His Excellency the President of the Republic of Kenya to immediately intervene in defense of religious freedoms and legal pluralism, and to safeguard the rights of Muslims to be governed by their personal law as enshrined in the Constitution. 3, demand that the Office of the Attorney General to file a constitutional interpretation reference or advisory opinion to protect religious and cultural minorities from judicial overreach that erodes legal safeguards for their faith-based practices. 4. Urge Parliament, especially Muslim representatives and members of the Justice and Legal Affairs Committee, to move swiftly and introduce legislative safeguards to protect Muslim personal law from erosion and misrepresentation by secular courts. 5. Call on the Qadhi's court and to issue clear guidance to the Muslim community on how to protect their families and estates under Islamic guidelines. 6. We strongly urge the judiciary to exercise caution and inclusivity when making rulings that impacts constitutionally protected religious practices. We remind apex judges that Islamic law, and particularly the Qadhi's courts, are part and parcel of the negotiated historical engagement agreement between the late President Jomo Kenyatta and Zanzibar that enabled Kenya to acquire the 10-mile strip, making Kenya what it is today. Thus, any chipping away of religious rights is not just reckless, but can be extremely dangerous to the stability of our state. Finally, we call upon the Muslim community to remain informed, united, and proactive in defending our religious values within the framework of our country's laws. This is a matter of constitutional rights. Muslims in Kenya have never and will never impose our religious rulings on others. But we will not accept imposition of rulings that dismantle our faith, values, and practices. We therefore remind the state, judiciary, the general public that Kenya is a multi-religious society, and any move that respects, overrides, or forcefully harmonizes personal law will only lead to division, mistrust, and constitutional crisis. We stand firm, we stand united, and we will protect our faith, our families, our freedoms by all legal and constitutional means. Thank you.
Steve, thank you for your very good question as to what legal avenues are available. As all Kenyans, we understand the hierarchy of the legal system, the judiciary, ending with the Supreme Court, which makes us appalled that the Supreme Court did not exercise care in the decision they are giving and the implications for it to be a precedent. The framers of the Constitution did not leave that lacuna whereby the Supreme Court decision can have the finality that it appears to have, in the sense that the legal redress, there is a small window of review which needs to be done within 14 days, so that the aggrieved party may make an application to the Supreme Court to indicate how heavy this decision was and the extent of violation of the law and the Constitution by those who pronounce this ruling. They are, after all, human. And maybe the representation that was kept before them missed the mark. And we must also indicate that this lady did not have anyone to represent her. Can you imagine a citizen, a Kenyan, a woman at that, aggrieved, going to the Supreme Court without the benefit of legal representation? It is unimaginable. So there are good grounds in terms of the issues raised and the astronomous constitutional implication of this, that the Supreme Court would be well advised to allow this review. It shouldn't be like that hijab case, which it has just let it linger for years. It's supposed to be heard with the urgency it requires and the seriousness that it requires. Yes, there is a legal redress to this one. Lawyers are working on it so that it is done within the time frame. But while that time frame is going to be honored, the Supreme Court in turn must honor timelines in reviewing this matter. Thank you. Jambo la kwanza, nashukuru kwa swali lako. Tunawapa nasaha gani Waislamu kwenye huu mpangilio kwamba Qadhi's Court imewekwa as the subordinate court. Juu yake kuna High Court, Court of Appeal na Supreme Court. Ningelipenda kusema hivi kwamba kwa mujibu wa ile protection iliyoko kwenye katiba, yale mambo ambayo yanahusu Kadhi's Court ni mambo ya personal law ya Waislamu ambayo yamekubalika, yamehifadhiwa na hii katiba na sheria ya Succession Act, kumaanisha kwamba hata kama imeenda appeal to the High Court ama imeenda zaidi kwa Court of Appeal na Supreme Court kama ilivyokuwa, ilikuwa ni lazima kwamba mahakimu wakiangalia hili swala watoe hukumu yao kwa mujibu wa zile sheria ambazo zinawahusu Waislamu kwa masala haya ya mirathi. Na kwa Muislamu hatuna budi ila tukipelekwa on appeal, lazima hiyo appeal iwekwe, maanake huo ni mpangilio wa mahakama. Lakini haina shida, kwa sababu ikiwa hukumu yake itakwenda kwa mujibu wa sheria ya Kiislamu kama ilivyohifadhiwa kwenye katiba, basi hakuna shida kama Wakenya wengine kuelekea kwenye mahakama kama hizo. Na la tatu na la mwisho ni kwamba going forward, tumeona hapa tunataka wabunge waingilie haya mambo kivipi. Mojawapo ni kuiweka hii more clearly kwamba hizi mahakama za juu zikiwa zinajadili mambo haya, iwe ni kwa appeal ama in the first instance, ni lazima kuwe na panel maalum pale kumpa mwongozo yoyote, awe ni hakimu, awe ni Muislamu ama si Muislamu, aweze kuelimishwa na kujulishwa kuhusu mitindo na sheria na hukumu ziliomo ndani ya Uislamu kwenye jambo linalojadiliwa. Kwa hivyo hayo ndio nasaha zangu kwa Waislamu ambao bila shaka pia tuchunge hii dini yetu, tuseme kwamba haya yametokea kwa sababu ya makosa ya zina. Waislamu hawaruhusiwi kuwa na mambo nje ya ndoa. Kwa hivyo tunawaambia Waislamu washikamane na dini na desturi, wahakikishe kwamba tumekaa kwenye mipaka ya dini yetu ili tuache kuleta vijisababu kama hivi ambavyo vimetokea. Hilo swala si la Waislamu, ni la Wakenya wote, ambapo kwenye sheria na kwenye katiba tuzungumza si kama Waislamu, tuzungumza kama Wakenya chini ya katiba ya Kenya, kwamba hakutakuwa na dini yoyote ambayo itakuwa ndio dini ya nchi. Kwa hivyo chombo kama kile State House tayari kina status beyond the occupier of the State House. Ni chombo ambacho inaunganisha na ni symbol of the country kama vile bunge. Kwa hivyo chombo kama kile ikianza kuonekaniwa kwamba kinakwenda kwa upande mmoja ama mwingine, itakuwa si vyema. Wala hatusemi wala hatupendelei kwamba maadamu yatakajengwa kanisa pale, ijengwe msikiti pale, ijengwe sinagogi pale, ijengwe temple pale, itakuwa pale ni uwanja wa ibada, sio uwanja ya makazi ya nchi kuhusu utawala wa nchi.
Kwamba nyakati zimefika sasa, tamaduni zetu ambazo hakuoni kwamba kuna habari sasa umekusikia kwamba au ndio unapopatikana nao sasa.
Asante sana. Jambo la kwanza, Uislamu si dini ambayo yabadilika kwa wakati. Constant. Na tukenda na argument yako kwamba tubadilike sisi kama wananchi wanadamu kwa sababu wameendekwa kileo, ndio tumeona wanaume wanaoana na wanawake wanaoana na kuna ndoa baina ya baba na mama, ziko duniani huko sehemu nyingine. Kwa hivyo if we go by that argument kwamba we have to be modern according to what modernity tells us, tunaingia kwenye masala ya ushetani. Hilo kwa Waislamu hatuwezi kubali kabisa. Kwa hivyo aliyotuumba sisi, yeye the creator, the inventor knows our user manual. Hata ukinunua friji leo, ukiliendea kombo na user manual, ita malfunction. So that is the position of Islamic law. It's not negotiable. Jambo lingine wanaweza kuangaliwa school fee na maintenance katika uhai wa baba, na tumesema hapa kwenye hii statement wanaweza kupatiwa mali by way of gift ambayo hayawezi kupokonywa tena hata mzee akifariki. Vile vile yule baba ambaye anajua amefanya zinaa na amepata watoto wa kando, ilikuwa na tunao uwezo wa kuwaandikia wasia ama will, bora isivuke 1/3 ya ile property iliyopo, so that the remaining 2/3 inagawanywa kwa mujibu ya sheria ya dini ya Kiislamu. Kwa hivyo there are Islamic principles which are guiding this, na hapo ndio sisi tunasema mahakimu ambao hawayaelewi haya ilikuwa wawekewe panel wawaeleze kabla kutoa hukumu zao, na ndio hiyo tunataka parliament wafanye bidii, waweke sheria na procedures ambazo zitawaongoza mahakimu wote kuhusu mambo kama haya.